Thank you, Claire, and thanks to our witnesses for being here today. Many people in the public might be thinking, are they not going over old ground? Do we not know this already? And to some degree, I've said this before, the Media and Culture Committee, Joint Oireachtas Committee, it has a separate remit and function than we have. We have a specific remit from the Dáil to draft a report to document what happened and to make recommendations in regards to procedures. And it's particularly procedures that I want to focus on, because either two things happened. Either there were procedures absent or procedures were overridden. And I think they, in terms of going forward, in terms of the operation of RTE, I think it's both important that that is documented, recommended, and then RTE responds to it. So that is why the note of May 2020 is so crucial, because RTE is relying on a defence which says that Dee Forbes alone was the person who knew all of the pieces of the picture. And the evidence that RTE have given here before the committee, the CFO knew of the tri-party agreement, but not of the details. Ms O'Leary knew of the credit note, but not that formed part of salary negotiations. Ms Maludia said she didn't know of until 2021 about the indemnity issue. So the evidence sort of reflects the argument that only one person knew all of these details, and without that person being here, it's quite difficult for us to put together a report. But that note of that meeting should support your argument that Dee Forbes was the only person, or it would prove otherwise. And the absence of that note is really important from our perspective, because it backs up your case, or it doesn't. And the absence to provide it would appear to undermine your assertion. So that is why we've been very forthcoming documentation. This one piece of documentation goes to the very credibility of the case of RTE, that only one person had all of the pieces of information. And the question is, was the indemnity, which again you've relied on as a kind of key component, was that indemnity known much earlier? And that is really important for this committee to know. So I'd ask you to reflect again on the reasons why we want the document, and secondly, why you would not provide it. Because while there are other risks to you providing that document, there might be litigation risks and so on, there is also a risk of your credibility before this committee and the credibility of your answers. That's why we want it, and I won't restate the case that other members have made. Can I come back to procedures and so on? In regards to the raising of credit notes, were there procedures at the time which approved the raising of credit notes, and who was responsible for raising credit notes?
The commercial director would have been responsible for that.
Solely responsible?
Yeah.
Yeah. So given that we have discovered that the raising of the credit note created the cost neutral element of it, do you accept that a single person signing off on a credit note is not a robust procedure?
No, the procedure should have been better, absolutely.
Okay, and has RTE made any changes to those procedures?
Yes, we have indeed. Financer across all of these as well now.
So how many people sign off it, and how is that done?
It would be duly signed off by the financial controller in commercial and the commercial director.
Okay. Can I also say we also fundamentally changed the nature of the barter account now? The barter account. Well,
that was my next question.
Well,
let me get to that.
Yeah.
So the first issue is in the raising of the credit note. The second question is the issue of RTE providing indemnity, and I imagine providing an indemnity always comes with a cost, right? So the question is, who signs off on an indemnity within RTE? Was there a procedure for doing that at the time? Ms Maludia, perhaps?
Yeah, I think it differs. If there is a formal legal agreement and the indemnity, it would be the business division, and depending on the exposure, it might go further up to the Director General.
So the business division is empowered to provide an indemnity on behalf of RTE?
Yes.
Okay. Do you believe that that is a robust enough procedure, given that in this case the businesses did provide the indemnity, and yet other people should have known about what happened?
Well, in this particular case, it was the Director General that
Yes.
provided indemnity. So the escalation point would always be to the Director General in the context of an indemnity.
But surely the failure here was that the broader management team were not aware of all of the pieces. That is your argument. So my question is, when RTE provides an indemnity, at the moment that can be provided by the business division, and it may be escalated. The question is, are there any procedures in regard to RT? Like we could, the indemnity of 1 million, of 2 million could be provided on that basis.
Yeah, it is slightly more complicated than that, but
Okay.
yes, but the escalation point is the Director General. For me, the failing here relates to the payment, the fact of the payment not being known more broadly. For me,
Yes.
and I accept other people take a different
Do you accept
point
as part of procedures and so on, provision of an indemnity was the key reason why the additional 2 payments had to be made? That again, that is RTE's case. So my question is, if that is
It's not the provision, it's the knowledge of the indemnity. That's
yes,
more
but also
important.
it's provision, because if it's not given, then you don't need to know about it.
Yes.
My point is, are there any changes in procedures for the provision of indemnities? And I'm not hearing yes.
There isn't a
Okay.
provision because
Again, I think you should reflect on that. and it might-
Deputy, sorry, can I just say, just in terms of, I mean, the indemnity was around in this case, the employment contract of a presenter. Now, I should say there are complete new procedures in place for contracts to presenters, which is, namely, they have to come to the full leadership team now and not be decided by 1 or 2 members or the DG on their own. And secondly, there is oversight from the Board Remuneration Committee on any new contracts for presenters. So, if this was part of a contract for
Well,
presenters.
just to correct you, it was not the form. It was not form of an employment contract. That is the whole problem. It was the form of a separate commercial agreement that was underwritten. So,
But we've also made it clear there are no side letters and side deals.
yeah.
Now,
So
there's a single
that brings me
contract,
to my third question.
yeah.
In the provision of side letters to commercial contracts, surely they would form part of a single file, and that all of those would be brought to the senior management team. Is that now a procedure in place? So all commercial contracts are brought to the senior management team, previously the executive committee.
All presenter contracts, yes.
No, that's not the question. The question was all commercial agreements. Don't forget the tri-party agreement was a commercial agreement.
no, so all presenter contracts are brought to the ILT, and then there's been a revision to the financial authority limits, a reduction in them.
So if in the morning RT facilitated tri-party agreements for all of their top 10 presenters, right?
No, there's no tripartite
No,
agreements
no.
anymore.
If RT in the morning, if individuals RT created tri-party agreements for every single one of their top 10 presenters, okay, that document and any side letters would not necessarily be brought to the senior management team.
It would, because it would be part of the presenter arrangement and it would come to the ILT.
Okay, and so my question is, all side letters and the legal contracts should be treated as one
Yes.
bundle.
Deputy, if I could
Is that
also...
the case? And that is the case?
That is the case, but I would also say, I've made it clear there are no side letters now on presenter contracts. It's all in a contract.
Yeah. The next point then relates to the signature and I suppose the finalisation of contracts. There's really wholly unacceptable practices here where contracts were agreed and then signatures were only applied much, much later. Were there procedures and procedures in place which related to following up on signatures of contracts or completion of contractual arrangements? Who within the RT would have been responsible for that?
Well, the signatures in relation to the other parts of the agreement were all fine. They were signed after they were agreed. The tripartite agreement, because it was sent in kind of without any other detail the following year, we just haven't been able to locate a signed copy. We
So
don't
my
know.
question was that a breach of existing procedures or an absence of procedure?
I think it was probably an absence of procedure.
Okay. And then in regard to the barter account, I take it that you have put in place measures in regard to the barter account and that more than one person or division can sign off on spending and so on, and that there won't be...
So Deputy, yeah, you can no longer spend, since April 12th, 2023, you can no longer spend through the barter account. It's simply for revenue.
Okay. I'm really running out of time, so I want to rush on then to the issue of... There's been an attempt, and I think a genuine attempt, to protect more junior members of staff from releasing their names and so on. And yet there are times and occasions when more junior members of staff were aware of key facts and that information may not have been scaled up and so on. And I think the legal note and the preparation of that legal note at that meeting was one example where key discussions were taking place, and yet that information, although because the Director General was there, it was felt, well, if the DG knows, then all of the senior management team should know. My question is that where the DG can act in a solo manner, are there procedures in place so that junior staff members will report to their own line managers about commitments that are made when they are at meetings? That, again, seems to be one of the key failures. If the DG wanted to go rogue, and I'm not suggesting that she did, but I'm saying if she wanted to, surely there were checks in place where other departmental members, albeit not the senior person, were present at meetings.
I can take that. And I know you've said you don't want to say going rogue. The giving of the indemnity was within the capacity of the Director General in her function as Director General. So there's no question of her having done something outside of her remit in that. In giving that indemnity. You might agree or disagree with that approach, but it was entirely within her remit in the Office of Director General. In the context of junior members of staff, there are plenty of procedures in place where people behave wrongly and they can bring that information to the appropriate person.
Okay, and just one last point, Chair. I do need.
Very briefly,
yeah.
I'm sure, over time.
So there was one issue. Previously, I asked Mr. Kelly in regards to his knowledge of the assets account. He consistently said at his evidence at the time that he was not aware of the assets account at the time. You have provided us with evidence in regards to an additional invoice between CMS in regards to the Chernobyl lunch. I suppose it should be noted that that invoice was made in January of 2023, whereas the at the time reference of Mr. Kelly was in 2022. So would you concur with that assessment of the timeline, that Mr. Kelly's evidence that at that time he didn't know who Astus were or what, that in no way is diluted by the knowledge of Astus in 2023? Would that be a fair assessment of that?
Correct.
Yeah, thank you. Thanks, Mr.